Okay, guys, we're gonna go ahead and get started. Just a couple of housekeeping items for you before we begin. We are recording tonight's presentation, and we'll send out a copy of that recording along with the slides and the handouts that you have already received in an email, but I'll send that out again in case you don't have access to those. So you'll have tons of follow-up information from tonight's presentation. If we have questions as we go along, I'm going to ask you to go ahead and put those in the chat for us. We'll read those out for Gary and he can answer them. We can always check back in with you, turn on your mic if you need to get clarification. But for the most part, we'll have participants remain muted throughout the presentation just to cut down on background noise and that sort of thing. If you are able to rename yourself, if you do not have your current name, first name and maybe last initial showing as a participant, that'll help us reach out to you if you do have a question and we need some clarification. Great. We are going to get started here in just a second. I am Eva Bloom from the Ohio University Credit Union. My job is to handle our educational outreach, so I'm really glad that everybody has signed up today to be here with us virtually since we couldn't do it in person this year. We want to make sure that these programs are relevant to you and get information about how we can continue to provide information that you need to be financially happy and healthy. So I will have a survey that's going to be in the chat at the end of the presentation. You can put that online and give us some feedback. I will also include that in the follow-up email if you can't stay till the end, but you do want to provide us some information. We will go ahead and get started by introducing our speaker today, Gary Hunter. Gary Hunter is a local government and financial institution attorney with over 44 years of experience. Mr. Hunter was elected law director for the city of Athens, Ohio for 30 years and is currently the legal counsel for Nelsonville, the Southeastern Ohio Regional Jail, Athens Hocking Solid Waste District, Athens MEGS Educational Service Center, Ohio Municipal League, Ohio Municipal Attorneys Association, and the Ohio University Credit Union. Mr. Hunter has represented the credit union as corporate counsel since 1976 and has conducted estate planning seminars for over 30 years for the credit union. And we're certainly grateful for the time that he's spent helping our members understand these issues. He has a limited group legal services contract with the Ohio University Credit Union since 1976, and that allows credit union members a free telephone conference annually and reduced fees on estate planning and real estate documents. Please welcome Gary Hunter.
Thank you, Eva. Can you all hear me? If you can't hear me, raise your hand or something so I can see some of you. As Eva indicated, I've done these seminars for about 30 years or so, but they've always been in person. And I have a style there. I usually encourage a lot of conversation during the process so that we can get your questions answered as much as possible. Obviously, we're doing it in a virtual format this year. So to keep that focus going a little bit, the chat is there available for you to write comments, and I'll be looking at the chat as I speak and can answer those questions as they come up on the chat line. But Bill, also free to seek to be unmuted and ask your question in person. I think a lot of times those give and take in person is the good way to get these questions out for people to, whatever your question is, be aware that there's probably several people that are thinking the same thing and just haven't asked that particular question. So the evening goes much faster, much more entertaining if you participate, and that's what this is designed to be, is a participation presentation. It is an informational session for you. I try to answer as many of your questions as I can throughout the process, but feel free to take advantage of being able to call me separately and talk to me individually about your individual situations. You do have that right to talk to me for 15 minutes. We do have a texting system that's been set up in my office, and you just have to text to my office number that's in the phone book, 740-592-5580. And that text will appear on my phone, so I can answer that way also. And we also have the capability for at least the last couple of years to do Zoom meetings with our clients also on a one-on-one basis rather than have you come into the office. Having said that, estate planning is something that most people think is only for the elderly, and it's really not. There's 3 times, basically I tell people there's 3 times throughout people's lives when I think they should have a conversation with a attorney about estate matters. Can anybody, either through the chat or unmuting your phone, tell me when you think those 3 times are? You're not being graded on this, by the way.
We've got marriage, coming from 2 participants, birth of a child,
retirement. Very good. Home buying. Yeah, you're a good audience. Yeah, I usually tell people that when you first get married, you may want to consider talking about it. It's usually not something that's on the front of your mind, but as soon as you have a child, you do want to consider talking with somebody and probably putting a will in place. Does anybody can either by the chat or by unmuting tell me, what does a will do for you? I've stumped you all, right?
Protect assets we've got coming in.
Yeah, protect assets. Basically, it's a distribution of your assets, protects your loved ones. Yeah, ensures your children are protected. Those are the right kind of thought process. Really, it's a transfer of your assets to someone else that you want to have your assets that you no longer need because you're deceased at that point in time. So, and it's also a way of taking care of your children in the event that you would die before they would become adults. So there are several things that are in a simple will that take care of some of those things, but there's also other things, we'll talk about those later, that you can do that take care of your things right now for you. A will is a document that is only effective after you die. I've got a PowerPoint over here. I don't use it much. I really don't use my materials much when I'm talking with people. So I'll change it periodically, but it's just a very basic PowerPoint that kind of keeps me on going on points that I might forget to talk about otherwise. So what is in, let's deal with the children's situation first. Why would you want to make a will for children? I mentioned one, that situation, that's to take care of the situation that the spouses are involved in an accident or something and get killed simultaneously or die within a fairly short period of time before the children are adults. What do you think you can do in a will to take care of that situation? Assets get passed to them. Yes, but there's something more. Well, the rule in Ohio on assets to children is children can have assets, but they can't spend the assets without court approval.
We've also got a guardianship coming in as a suggestion.
Designated guardianship, set up a trust, take tax liability. The main thing you can do is set up the guardianship was the right answer as far as I'm concerned. You set up what's called a testamentary guardianship for your minor children. In other words, you are nominating in your will somebody of your choosing to be the guardian over your children until they're adults and take care of their financial situation, take care of them. And what kind of things would you might want to consider before you select somebody to be that guardian over your children? Stumped you all, huh? Well, you might want to consider, a lot of people come in and they say, well, I think my parents might be a good choice. You think that's a good choice, you folks? No.
No.
Kay is probably right. Bonnie is probably right. Aneely's probably right. The answer usually is no. And the reason for that is there's usually a great age discrepancy between the age of the minor children and the age of your parents. And you probably haven't experienced this yet, but usually parents, as you get older, around my age or so, and I'm not telling you how old I am, but around my age, it's nice to have children come and visit you, but it's really not nice to have them live with you on a day-to-day basis. They're too active. They're too their interests are too different from what your interests are. Their sleep habits are different. Amen from Maryland. I see that. So parents are usually not the best choice. They usually don't have the patience anymore that they would have had as a parent in doing that. They love their grandchildren, but they don't want to be with them day and night. So that leaves you some other choices. And usually it falls back to, when I have this discussion with people, I say, well, think about brothers and sisters. And that's a choice you have to make on an individual basis. Could it be, one brother or one sister is willing to do it? You need to talk to these people in advance of actually doing your will to see whether they're willing to do that, whether they want to take it. Do they have children that, they don't want another 3 children in their household to do. So brothers and sisters are a possibility. The other thing you have to think about is, where do they live? Are my children going to be uprooted and moved from Athens to Columbus, or uprooted and moved from Athens to another state? You may not want that. And so you may want to provide that if you have a single brother or sister or a single person, another person that can do this, do you want to allow your children to have your house for them to stay in? These are all kind of difficult decisions that you have to think about a little bit when you're putting this in place. And a lot of people don't like to think about those things because we all think we're immortal and nothing's going to happen to us. But when it does, the more you've thought about these kind of things, the better off it's going to be for your children. So we usually have some fairly lengthy discussion when people come in and they have minor children about this kind of thing. Usually there's one brother, you get into 2. Is it the wife's brother and sister that's going to take them, or is it the husband's brother and sister that's going to take the children? Is there a great deal of discrepancy in the age between the children? Do you have like a 2-family situation? One child is 15 at the moment, and then you have a couple twins or something that are 4. In that situation, would it be appropriate to have somebody else be the guardian until that older sibling becomes 18, and then have the guardianship transferred to the sibling at 18 to take care of his or her twins, brothers and sisters that are a lot minor age? Or is that too much of a burden on them that would stop them from being out and getting a career and doing those kind of things? So it's a lot of thought that goes into that. Sometimes it's based on a friendship kind of situation. A lot of times people put that in a will, and I always tell people a will is a living document that's only effective until you die. And that's kind of an oxymoron kind of statement, but it's really true. It's a document that you have to take out and look at periodically, and as life events change, your will might need to be changed in it. So certainly when young people come in and just start a family, that's one of the things we talk about that goes into the will. As you reach middle age, that's not your primary reason or what you want to consider in a will. Then you may want to.
Before we move, I'm sorry, I apologize. Before we move on too far from the guardianship, we did have a question that came in regarding guardianship. Is it possible that a guardian could be appointed, a guardian could be named, that guardian could appoint an appropriate person to be a caretaker from day to day? Is that something that you'll see with guardianship?
The answer, that's a good question. The answer is yes and no. A guardian is appointed by the court. The guardian appointed by the court is the person that is responsible to report to the court on the conserving the assets and the day-to-day operations of taking care of the children. Does that mean the guardian cannot pay somebody else to perform that caregiver function? Certainly, and that does happen pretty frequently in a guardianship situation. But just remember that the appointed guardian is the one that's ultimately responsible for the actions of those caregivers and making sure that those caregivers are not taking money from the children inappropriately, or not abusing the children in some other shape or form. So it's when you accept a guardianship, you accept the right that you're going to have to be hanging around overseeing what's being done. Can you provide for other people to take care of a lot of these functions? Yes, and that's done. In many cases, I've been appointed guardians in incompetent situations, and obviously I don't know these people. I do visit them and stuff, but I am hiring other professionals on a pretty much a day-to-day basis to take care of certain their needs. So great question, but remember, if you're the guardian, you are the ultimate responsibility for taking care and seeing that the people that you hire are in fact appropriate. And there are other kinds of situations for guardianship that will come on other than just for minor children. When you get to middle age situation and you're coming in to talk to me, usually your children are grown or near grown at that point in time. And the main reason you're coming in to talk to me at that point in time is because it's not because of minor children. It's because you now have accumulated assets, significant assets, usually at that point in time. Usually when you come in to me and you just got married and you just had children, having, a couple $100,000 in the bank is not what most people come in to me and tell me they have. They're just beginning to buy a house. They don't really own it at this point in time. They have more expenses than they care to admit to me at that point in time. But when they come in at middle age, they do have assets. They do have sometimes issues with children and stuff at that point in time. When they come in, you may have a child with special needs. You may have a child that is proving to be pretty casual with their money. It's about the easiest way I can phrase it. They're spendthrifts. Money comes in their hands, it goes back out their hands the minute it comes in. And so you're somewhat concerned about whether they will just waste the money. In those kind of situations, we talk about another document, and I'm going to ask you if you can think what that other document might be that's created within your will, and it's not a guardianship. Trust. All right. Am I pronouncing that Neely? Is that correct? Tell me in the chat line whether that's the correct pronunciation of your name.
That is. Yes.
That is correct. Okay. Yeah, Neely's correct. It's a trust. And most people think of trust as some big freestanding document that you have and those are available. We'll talk about those a little bit later in the presentation, but I do much more in the way of trust in simple trusts that are located within your will. And they usually, obviously in the first instance, usually most assets go directly to the other spouse or the other significant other in the relationship. But after both of them are gone, then they may or may not want to give all of their assets equally to all of their children or all of everybody. If they're talking children, you may have one or two that you think are quite capable of taking care of the assets and not squandering it, but you may have one that you don't. The age of majority in Ohio is what age? Now, 18. Yeah, there we go. 18 is correct. Ohio regards, once you reach the age of 18, as you're an adult, you're legally able to take care of your affairs, you're legally able to do everything. Without raising your hands too much, how many of you think that all of your children really are totally mature at age 18? Yeah, not too many, I don't think. Yeah. So a lot of times people think that, I'd like to have my son or daughter to have some use of my money if they're in the 18 category when I die, but I don't think they should get all of my assets to spend at that point in time. So we talk through what do you think you would want to have? What age do you think? And usually it comes back, 50 or 60, and I tell them that's not appropriate. What we talk about usually is 21, because it used to be 21 was the age of majority, and so usually a lot of times we talk about 21, a lot of times we talk about 26, 25, 26, because 25, 26, you've usually completed your post-high school educational requirements and are getting a little bit more settled in life and looking for some money to buy a house or something, instead of that trip around the world that spends all of your money in one big spree. So a lot of times we'll do a trust within a and these are all fit in the simple definition of a simple will for me that I'm doing for you, and for that price you'll see at the end of the presentation. That's really quite good for the because of the OU Credit Union Group Legal Services contract that I have with you. So I can tailor a number of trusts for you that do different things. I got a comment here from gentleman. I'm going to inherit a trust. I want to set up a trust for my children. What steps do I need to do to accomplish this? If you're going to inherit a trust, and some of these things I can only talk about in broad terms, in this presentation, a lot of times I have to sit with you and find out a lot more detail what your situation is. But if you inherit a trust, I'm assuming that's a trust that is an inter vivos trust that was set up for somebody, and there's a fair amount of money, and they're now terminating the trust, and you're going to come into a bunch of money as a result of the trust being terminated. In those kind of situations, you would be setting up what's called an inter vivos trust for your children. So you wouldn't be appropriate to set it up in your will, most likely. So you'll be setting up a separate individual trust for them. It's a separate document from a will. It's a separate entity. And you got to remember, though, when you set up a trust, those are individual entities. They're separate from you that would pay taxes separately, et cetera, on it. So you may want to do that. You may want to, again, control those assets for your children yourself, and then provide in your will or something that a trust is created in the will. So there's a lot of different things you can do. It all depends on what your goals are, what the amount of money is we're talking about, how many children you have, what they may or may not you want them to do with that trust money, et cetera. There are people with no children here too, just for the context. Yeah, we're going to get to what happens otherwise when you don't have children, but I think a lot of people do have children, especially at this age range that we're talking about. When we get to the next time that you do will, it's probably not with children and so forth. And we can kind of go there now. I can kind of transition the next time that you may want to consider doing a will, or if you don't have any children at midlife and so forth, you've got to come in and do a will. And you're going to be doing, well, where do I want my assets to go? Obviously, you want them to go probably to your other spouse or significant other. Beyond that, what do you want to do with your assets? In that situation, we talk in terms of it's possible to do what's called specific requests within a will. And we'll talk about, well, do you want to give your church X amount of money, or do you want to give Ohio University X amount of money, or do you want to give the athletic department or somebody, or the School of Music, or et cetera, et cetera. I want to set up an endowment, et cetera. We'll have all those kind of discussions. And then if you've got special household items and so forth that you want people to have, those can be special bequests that we can put into a will. And those are things that we will talk about and talk through for people that have reached that stage that don't have specifically children that they want to leave everything to. You got to remember, a will has to transfer all of your assets, or become whatever you don't transfer becomes intestate and transfers under the intestate law. So you can't have a will that just goes everything down with specific requests. You've got to come down at the end and say, and then everything else that I own, I want to go to something, either some living person, into a trust for somebody else, or into an endowment or something. So you got to think about creating and transferring all of your assets when you do the will. And those are usually the conversations that we have as you reach the life, you're into later life, beyond late 50s into your 60s, and sometimes farther into your 70s, and those kind of concepts. When you get into much later life, into your late 70s and early 80s, the conversation again changes, and the will becomes less important at that point in time. It still is necessary to kind of have it as a backup kind of situation, but you begin to talk about, how do I make sure I have something left to transfer to somebody? Because I may get into a situation where I have to go into an assisted living or to a nursing home situation, and I don't know whether I have enough money to pay for that. How do I live? How do I keep the state and the federal government from coming in and selling everything I have? As you know, if you go into a Medicaid situation, you're only allowed to have $2,000 of assets. So then you're talking about transfers during your lifetime for the most part. And that's when we get into some of these other documents that I'm going to talk about that kind of complement the will situation. You can do a survivorship deed, for instance. Usually most people at that point in life are very heavy in real estate. Is probably their most valuable asset that they have. Second to that would be their bank accounts that they would have, and to a lesser degree, a lot of times, at least in Athens, stocks and bonds and life insurance and those kind of things. Once you get into those kind of discussions, we'll talk through about the fact that there are things you can do that will take your assets out of probate and never have to be probate. I had somebody come in the other day and said, if I do everything you tell me to do, it doesn't sound like I'm going to have much left to probate. And I said, that's exactly right. We still have a will there in case you have, you go out and win the lottery in the last, 4 or 5 days before you die or something. And for a backup situation. But if you do what I'm telling you to do, you should be able to really minimize what amount of assets have to transfer as a result of an estate. And of course, the question comes back, why are you telling me that? And I go, well, I'm not in business just to make money and tell you to probate stuff when you don't really need to do it if you follow these steps. So what do you think? I talked about the survivorship deed. Survivorship deed, think about that as being the same thing as a survivorship bank account. I'm sure most of you are aware of a survivorship bank account. In 1974, Ohio created the survivorship deed situation. Originally, it was just between husband and wife, and then later it was liberalized, and now you can do a survivorship deed between anybody. When you have a survivorship with the terms of the deed, and so when somebody dies and comes into my office and they have a survivorship deed, I just request a copy of the death certificate, and then we do what's called an affidavit succession under the survivorship deed, and the property is transferred in the auditor's office and recorder's office, and it's a done deal. So then your title then is vested in the original deed that you got that was to you and your significant other, your spouse, or somebody else. And the other half is vested into you by virtue of the document called a affidavit succession under survivorship deed. Can you please repeat what a survivorship deed is? I heard some glitches. Sure. The survivorship deed is a deed, and quite frankly, right now, it's the most popular form of deed that's out there, where there's 2 or more people owning a piece of property, that takes the title into, in the common language, is to John Doe and Mary Doe, or John Doe 1 and John Doe 2, for their joint lives, remainder to the survivor. That's the magical language that's in a survivorship deed. The other deed is a tenants in common deed, and it just says to John Doe and Mary Doe, or John Doe 1 and John Doe 2, as tenants in common. And the difference between the two of them is when one person dies, the tenants in common has to go through probate to be transferred. If it goes through survivorship, it doesn't go through probate. I've got a question. What kind of tax implications are there with a survivorship deed? There are no tax implications right now with the survivorship deed, other than paying the cost of recording it in preparation of the affidavit, which is fairly minor. The Ohio has done away with the estate tax, so let's regenerate into that, curve into that side of the comment. So prior to, they did away with the estate tax as of January 1 of 2013. So all of us that are currently alive right now are not subject to an Ohio estate tax. You'll see that the Ohio estate tax is still on the books, because there are, believe it or not, there are people that come in for me to do something where somebody died 15 years ago or so. Well, if they died 15 years ago, I'm sorry, there were estate tax 15 years ago. And so we would have to look and see if there were estate taxes that would be due. So right now there's no Ohio estate tax. However, there is still a federal estate tax, but that threshold is really high, like I think 11 million or something like that right at the moment. So for most people that I come in contact with, federal estate taxes are not an issue. However, the federal government did change the law a few years ago now, not very long, about 2 years ago, I think, or so, that income on property transferred is taxable as income tax, not as estate tax. And that's not really as bad as you think, but anything over $600 of income in a year coming in to an estate is a taxable event. Once the property is, the last year of the tax year, the way that the law was written, that income should be transferred to the beneficiaries, and they have to file what's called a K-1, and they get that income to report on their own individual tax return, which is actually better because, one, it's a smaller sum of money, and the tax rates are better for the individual than they are for an estate anyway. But just be aware, but you're not paying any taxes on, there's no such thing as estate taxes in Ohio right now, and the federal estate taxes are so high that you're probably not going to be subject to estate tax. So estate taxes are not an issue. That used to be why people were doing trusts, but they're really not necessary for that matter. If there's only one owner, what should a person do to prevent going through probate? The same thing a one person can do that a multiple people can do to avoid probate. One is to make sure that all of your bank accounts are in survivorship or are in transfer on death, payable on death situation. Payable on death has been around for a really long period of time, decades and decades, but it was kind of out of favor when survivorship came out. And I'll tell you that a big difference you got to think about between survivorship and payable on death. Payable on death, the beneficiary under payable on death has no current interest in the property or the bank account. Survivorship, they do. They have the right to go in and withdraw money from it. They have the right to spend it because they're a co-owner of the piece of property. They have to jointly report, the income from it on their income tax, etc. So, in the case of a spouse or a significant other, owning a joint account in survivorship works pretty well. In the case of who you want to have your property when you die, remember, if it's in survivorship, it's going to go automatically to the other person. So we go back to this one owner situation. How do you prevent it from going to probate? You put it in payable on death. You go to the financial institution and say, I want to sign a card saying that my bank account is payable on death to one person, two persons, 10 persons, whatever. And they will keep that, and then they will transfer that on your death with a copy of the death certificate to whoever's listed in that. So that's one way to handle your bank account. With your real estate, believe it or not, you can do the same thing. It's called a transfer on death deed situation. And Ohio authorized that about 15 years or so ago. And it's now called, instead of a transfer on death, it's now called a transfer on death affidavit, same thing basically. And what you're doing is the person has no present interest in your real estate. You can go ahead and sell it, and it just cancels out that transfer on death provision if you sell it. Same thing with the bank account. If you spend all your money, there's no transfer on death. It's not going to help you at that point. So you can put your property in transfer on death situation. You keep all the instance ownership of it. You could put it in survivorship with your children or anybody, quite frankly, that you want to have it. If you're elderly and you have children and you want them to have your real estate, but you want to live there for the rest of your life, sometimes we will put it in survivorship and reserve a life estate to the people so that they can live there and use it during their lifetime, and then their children will automatically have it. Otherwise, you have to think about that. If you put it in survivorship with your children, reserve a life estate, you're still going to get your homestead exemption because you're the one that primarily lives in the property. However, you can't sell it without your children's consent to do it that way. And you may be, this is where the discussions with Medicaid come into play and so forth in my office on what's the best thing to do. If you put it in transfer on death, you have all the instances of ownership, but if you don't have a lot of money and you may be going into a nursing home and you may have to go on Medicaid, they're going to take the property, quite frankly. So you may be better off to go ahead and do the survivorship and reserve a life estate, where Medicaid can only reach the value of the life estate. Or you may want to just transfer it to them, period, and keep nothing, in which case Medicaid can't take anything. But there's catches and all that too, because Medicaid has a look back period in which they can undo what you do to avoid paying back Medicaid for what they pay for your care. And does anybody have any idea what that look back period is? Let me catch my breath a little bit if you answer the question. 7 years, I hear from Kendall. 5 years from.
Yeah. We also may have had a question slip by in terms of, before we get maybe into the look back period, in terms of making a change to a will. If there's changes that someone would like to make, can they strike out what they no longer want to happen, add an addendum and have that notarized? How do you go about changing a will?
Sure. I'll answer the other question real quickly. The answer is 5 years for the look back currently, but they change that stuff all the time. The great question on the change your will. Ohio is really, really specific about execution of wills. Ohio does not allow you to handwrite a will and sign it. It will be invalid. Ohio does not allow you to, like you can do on other legal documents, cross out something, initial it and date it, and it's okay. You do that on a will and you've invalidated the whole will. So you cannot do that. What you have to do in Ohio is you have to do what's called a codicil to the will, in which you go back to the original formalities of the execution of the will, and you simply change paragraph 3, paragraph 4, or whatever to the will. And it's then is an addendum to the will. The addendum is the correct title, but it's done by a codicil. It's attached to the will, and then you read the will, and then you read the change that you made. And you know, I had a client that would come in about every 3 years and would do, you know, codicils to her will because people fell in and out of favor with her. And I once said, why don't you just do a new will instead of doing the codicil? And she came back to me and she said, because I want them to know what was in the original will and what's in it now. I don't hear people laughing, but I assume you are laughing about that. And that's a true story, quite frankly. But the better thing really is, if you know, it depends on what the codicil is. The difference in price is a codicil in my office right now is half the price of a will. So you're talking $40, $45 or something like that to do a codicil versus the will. And you may or may not want people to know what was in the original will. And certainly if you do a codicil, they know what's in the original will because it's there. It's just a change in the original language. If you do a new will, they don't see what was in there earlier, because under Ohio law, whatever the will is that's closest to the date of your death is the will that is valid, assuming it was executed with proper formalities. Oh, thank you, Bethany. I like telling jokes that somebody gets them. I have a previous will from the state of New York, but was considered transferring to a trust. Are there any issues with that? Possibly. You got to remember, the formalities for executing a will are peculiar to every state in the union, and they're not all the same. The ones that I deal with, there's a lot of people in Ohio that are snowbirds that own property in Florida or Texas or South Carolina. It seems to be the most popular ones. And those states are really pretty easily, when you own property in 2 different states or multiple states, you have to do what's called an ancillary administration in every one of those states. So one state ends up being the primary state for handling the estate. Does anybody have an idea how we determine which one is the primary state for handling the estate when somebody dies? I see you're all just fighting to jump in to answer this question.
State of your residence.
Yeah, state of your residence, Samuel says. Yes, sort of. 180 days plus days in the state. State of the residence is sort of correct. It really is with this magical concept called domicile on it, because residence is really kind of hard to peg, especially when you're in Ohio for 6 months and you're in Florida for 6 months. Which one is your real residence? And so then you go back and you look at things like where were you registered to vote? Where were your cars registered? Where did you grow up? Kind of thing. Did you pack up and leave everything in Florida or Ohio? So that's kind of how we go about picking which state it is. A lot of times we will look and see where they made a will. If they made a will in Ohio, I kind of make the assumption, unless they made a big effort to move to Florida or something, that Ohio is their state of residence. Does it make a difference? Yes. If you make a will in Ohio, but you move completely to Florida, your will now has to meet the requirements for Florida. Now, some states are a little more lenient than other. Florida is pretty lenient, and there's a constitutional provision in the United States Constitution that says that states are supposed to give full faith and credit to actions that occur in other states. And some states are more liberal about doing that than others. Florida, South Carolina, and Texas are pretty liberal about that, unless we end up with a big fight among relatives, and there's a big estate, then they tend to fight about those kinds of things. The good thing for you in Ohio is we are so restrictive, and our requirements are so specific for execution of a will that it's probably going to stand a much better chance of standing up in other states. But I always tell people, if I do a will for you in Ohio and you move to Tennessee, or you move to Kentucky or West Virginia or someplace else, take the time, come in to me, and I will look up what the requirements are for that particular state, and then tell you whether you need to have a new will or not done in good practice. And then the question always comes back, well, can you do that for me? And the answer is usually no, because I'm not authorized to practice in these states. And you've got to be authorized to practice. I see you laughing, Sandra. You got to be authorized to practice in another state to actually do a document for them, or I can get in trouble with my Supreme Court on that topic. But I can tell you whether you really need to go to somebody in that state to change your will or have it done, or whether it will stand up in Ohio. But those are kind of things that honestly people don't think about. We have that discussion when you come in my office, and I always tell people those things, that because people are fairly mobile in Athens. They're here and they kind of move different places. Now, if you move somewhere else in Ohio, no. But the answer to the 180 days plus days in the state is a pretty good answer when you're talking about this is what happens most frequently, and I'll tell you how I handle it. Different attorneys may handle it differently. You live in Athens, you're elderly, you live in Athens, and you go to assisted living in Canal Winchester, and you die in Canal Winchester in the assisted living, but you still own your house in Athens, and you still own all your banking is done at the Ohio University Credit Union in Athens, etc. Where is your domicile? It could be either place, and so it really depends on. When you come into me, I'm going to say, well, I would say we do it through Athens, because that's where your real estate is. You have to do something with it and so forth. I'm most familiar with the Athens probate court than I am with the Franklin County probate court, which is where you'd be in Canal Winchester. And so let's try there. Do you think people are going to challenge the situation? So those kind of questions come up, and usually it's in that more elderly kind of situation where somebody is removed. Now, if you're just going into the hospital for the last illness, obviously that's a last illness kind of situation. But the ones I'm talking about where somebody's in a assisted living or something for 4 or 5 years or something like that. But they don't get rid. Now, if they get rid of their house and most of their assets, and the assets are controlled by somebody with a power of attorney or something like that, then you're maybe determined to be up in Canal Winchester for purposes of where the probate has to occur. And there's a difference between even county to county on how the judges handle probate issues. But if you do what I'm talking about earlier, you have your property in survivorship, you have, or you could put it in a trust. I don't necessarily recommend that, but you could, and there might be situations in which we would do something like that. Or you do a transfer on death deed situation. That will take care of your real estate and probably won't be a probate asset. If you do the bank accounts and have them in survivorship or with a payable on death clause on them if they're not in survivorship situation. And even, I think it's even possible you could do the survivorship bank account and still have a payable on death. What's going to happen is the payable on death will become second to the survivorship. So the survivorship will occur, but then there may only be one person standing after that. And so then when that person dies, the transfer on death will take effect at that point in time. So you do that. You can do on your life insurance, most people do one-step distribution to somebody, their spouse or significant other, children, somebody. Most people kind of forget to do the second step distribution. And what happens is somebody dies that's transferred to the spouse or significant other, and then they just don't do anything with it because it wasn't their primary, account or whatever. And so then, or that person died, the more likely that person ends up dying. They transfer it to they leave it to their spouse, and their spouse dies before they do. And then they come into me and they go, what do I do with this life insurance? And I said, well, now it's become an asset of the estate, because that's what happens when you don't have a beneficiary on a life insurance policy. It's an asset of the estate when you have to administer it under the estate and with your will. And that's sometimes not what people want to do. It is possible to put contingent beneficiaries on these documents and say it goes to my spouse or significant other, but if they're not living, then it goes to X person or Y person. And if they're not living, if you want that, you can do several down on that. And it's usually wise to think about that when you're doing it and go down a couple step distribution, because if you don't, it'll be fine when the first person dies, but when the second person dies, or if they die before you do, we all heard that the statistics that women live longer than men. So a lot of times the life insurance is on the life of the man, but sometimes the wife dies first, and then if you don't have anybody else as a beneficiary, so we're going to have an estate asset. So we point those things out to you, tell you to think about those and do what you want. If you have stocks and bonds, you can do the same thing. You can put beneficiaries on those. If you don't, then they become an asset of the estate. If you do, they're not an asset of the estate. So in this day and age, when I go through all these things with people and they get their stuff in order, when you come in, you're 25 years old, you could care less about these conversations. When you're middle life, you may or may not be concerned about it. When you're in your 60s and 70s and 80s, you are concerned about those things. So the conversations change that I have with people depending on where they are in life situations. So those, usually the conversation I have with people, I'll be honest with you, it's one-on-one, a lot of me asking a lot of questions, quite frankly, but it takes about half an hour to 45 minutes, quite frankly, before we come down to what people want to do in those kind of and sometimes it's just a will, sometimes it's a will and several other documents that are putting things in place. And let me talk about some of the other documents that we were going to talk about. I've already talked about the transfer on death deed and the survivorship deed situation, but especially this one doesn't apply just to the more elderly people that are on conversation here. It applies to everybody really, and that's the durable power of attorney for healthcare purposes. About 15 years ago now, Ohio decided to create these documents, and it really came out of the what I refer to as the Schiavo situation down in Florida. Is anybody familiar with that situation or know anything about it? Okay, Terry Schiavo lived in Florida, and she had some sort of a major illness, injury, and she was on life support. And she'd been on life support for a while. and the husband wanted to terminate the life support, and the parents did not want to terminate the life support for her. And it went on to a big court battle, and eventually the husband won, and they stopped turned off the life support. And then we got into a battle over whether she was to get, food and water, and eventually the husband won that one too, and he stopped the food and water, and she died. Ohio now has, about 15 years ago, taken care of that situation with the durable power of attorney for healthcare purposes, but they went beyond that situation too. The durable power of attorney for healthcare purposes allows a person of your choosing to make healthcare decisions for you if you're unable to make them for yourself. So if you go into a hospital and you're under sedation, or you're under, you've had a stroke and you're in a coma, or something, for any number of reasons, you might not be able to make your healthcare decisions. We all know that a lot in the past, 20 years or so ago, they would just turn to the spouse or the children and say, what do you want us to do? And they would do it. Doctors don't do that anymore. So if you have the durable power for healthcare purposes, you will allow a person of your choosing to make those decisions for you. It gets around the HIPAA requirements where they don't think they can talk to you about patients' consent for privacy reasons about the case. It gets around all of those kind of situations, and you can make those healthcare decisions for that person. It also includes the right to disconnect life support where there's no meaningful life as certified by an attending physician in concurrence of another physician. So when you have that document, you have allowed somebody close to you to make a decision to disconnect life support. Then Ohio goes on to say, I don't necessarily want to leave the decision of whether I get food and water if I don't die when they disconnect life support. And there's another box you can check, an initial in the document when you execute it, that says the default in Ohio is they'll give you food and water. If you don't want the food and water, you can check the box and initial it, and they'll withhold the food and water. That used to be something that everybody wanted to do. Nowadays, it's not really necessary to do that, because they'll put you under what's called comfort care in those kind of situations when they take you out of life support, you don't die. And that comfort care is usually morphine, and usually people pass within, unless there's a great possibility you're going to recover, will pass within a fairly short period of time. Can a person you gave the power of attorney to transfer those decisions to somebody else? Great question. No, because the power of attorney is given by the person, the grantor of that, and as a grantee, you can't transfer that. They weren't giving that permission to somebody else, but they can name alternates in a durable power of attorney for healthcare purposes. So you could have the durable power of attorney primarily to a spouse, significant other, friend, somebody, and then on another page over from it, you could say my first alternate is Mr. Y or Mrs. X or whatever, and my second alternate is somebody else, and my third alternate is somebody else. And usually these decisions to disconnect life support are kind of a family decision, is my experience with them. And I can tell you that from my own personal experience with my mother, who got into a disconnect life support situation. And my father was the first one, and I have two siblings, and it kind of went down by age on the siblings, and I'm kind of in the middle. My father was in no condition, nor did he want to make the decision to disconnect life support. So the three of us got together with our father and talked to him about the situation. And honestly, I was not convinced at that point that disconnecting life support was in the best interest of my mother. And my siblings respected my position. And so we waited for another 2 or 3 days until I was comfortable with that decision. And then basically as one voice, we decided that was the best thing to do, was to disconnect the life support. I think that's more common than not in the situation, the way these situations are handled. It usually kind of becomes a family kind of decision. Everybody has to feel kind of comfortable, because if you don't, it'll haunt you the rest of your life, quite frankly, if you make a decision too quickly on something like that. If you don't feel you can make the decision, Ohio is taking care of it in the form of another document. And that other document is called the living will. It's kind of outlined in the materials. The thing to remember about a living will, and I really don't have people go to the expense of me typing up a living will unless they can answer a question. And that question is, can you make it, do you feel comfortable making a decision to disconnect life support if there's no meaningful life? And if they say yes, which about 99% of the people say yes, then I don't normally recommend they go to the expense of doing the living will. The living will is a document that only deals with disconnecting life support. So remember that. A living will is a document that gives that power to disconnect life support to the attending physician. So remember that. And then remember the last thing, and that is the attending physician is required to attempt to contact somebody listed in the document. Not necessarily required to contact somebody that's listed in the document, but attempt to contact somebody listed in the document. So only deals with disconnecting life support. Attending physician makes the decision, and the attending physician attempts to notify somebody that's in the living will document to tell them they're going to make that decision. The person they contact does not have the authority to overrule the attending physician if he or she decides to make the decision to disconnect the life support. So it's a very restricted document. If you do that document, as I say, the only time you'd want to do that document is if you didn't feel comfortable making the decision yourself. You still would need to do the durable power of attorney for healthcare purposes, because it does not do anything about making healthcare decisions for somebody that is unconscious and can't make them for themselves or talk to the doctor. So if you do the living will, you have to do the durable power of attorney for healthcare purposes. If you do the durable power of attorney for healthcare purposes, you don't necessarily have to do the living will. Your call.
We have a question that came in here. What happens if there is no power of attorney, or I guess living will in that case as well?
Ugly. Ohio has the HIPAA rules, the federal HIPAA rules about privacy of an individual's condition. Sometimes doctors will tell you that. Doctors have an obligation to provide the care that they believe will benefit a patient. However, they get sued all the time anymore for malpractice if somebody dies in this. And so I don't believe they're, and I might be talking out of school, I don't necessarily think that all doctors are as aggressive as they would be if they had that document in place. But they do have some obligation to make decisions, but they get really squeamish when it's something where a leg has to be amputated, or, you know, something else is going on and you're going to become, you know, some major surgery where you have, you know, only a 50-50 chance of survival, or if you do survive, you may have paralysis on one side of your body or something. They get really concerned about those things. And so what they'll do is they'll say, go talk to your attorney. You love that one, don't you? And so they come and talk to me, and what can you do? And I say, well, the only thing I can do is, and these always happen, by the way, at about 2 a.m. in the morning, that I get these phone calls. And I said, the only thing I can do is go to my office real quickly and whip up a motion for an emergency order from the probate court to authorize this surgery. And then I can go wake up the judge and see if I can get him to sign it. And after he chews me out for about 40 minutes or so, he probably will sign it, and then I can run it over to the hospital, and they'll do it on the basis of a court order. That all depends on your probate judge and what kind of a relationship I have with them, because I obviously most of the times don't have a lot of documentation on something like that. But that is your answer. Either the doctor does it and takes his chances because he has an obligation of the Hippocratic Oath to try to perform what's best for you and hope that his malpractice insurance is paid up and current. Or you come to me as an attorney and I go to the probate court and try to get an emergency order out of the probate court to take care of the situation. There's one thing I can guarantee you in that situation: I'm not going to do it for $25. So it's going to be more expensive for you. I would say spend the money, spend the 25 bucks and have it done, have the document in place. Now, who should make this decision if you have no POA?
The one we just went through, Gary.
Oh, that's the one we just went through. Okay.
Yep.
That document, I mean, the Durham Power of Attorney for healthcare purposes is really important. What I get into is I don't want to pay you 25 bucks or 30 bucks for a reciprocal one of this document when I can go to the hospital and get it when I need it, and the hospital will provide it for me. And that is true. The document was the legislative action to create the document was a joint effort between the Ohio Bar Association and the Ohio Medical Association. And I don't mind telling you, we usually don't play together real well, but they did work together and they did come up with the document. And it is available at your hospital. Should you do it there? It's your call. I can tell you that a lot of them that I look at that have been done at a hospital are probably not executed correctly. And the reason that happens is because this is the way the scenario that a lot of times it plays out. You're having chest pains or something, and kidney stones or something, and you go to you're transferred by emergency to the hospital, or you end up in the emergency room, whatever, you end up in the emergency room, and they immediately sedate you. You're in excruciating pain. And somebody from the hospital social department brings you the document. And your spouse or significant other is standing there. They're in a situation of distress also, and they say, you need to fill this out and have two people, witnesses, and you need to sign it. And guess what? The social worker steps out a little bit so you can discuss the situation in private, and the spouse picks up the pen and puts her hand around her spouse or her significant other's hand and signs the document for them. And then they come back in and the spouse signs as one of the witnesses and somebody else signs as the other witness. Major problems with the document at this point in time, because one, a spouse can't sign the document for the other person, and two, how am I going to prove the other person even knew what he was signing when he's in extreme distress and he's under, a morphine drip? And three, you can't sign a witness when you're the beneficiary of the document. So right off the bat, there's 3 strikes against this particular document. Is it a problem? Probably sometimes not, because the hospital will honor it. And if the spouse or significant other recovers and it's all well and good, it's nothing's going to happen. But there's always that possibility that, the spouse or significant other wasn't the one that transported with the hospital. They were doing somewhere else, and it was somebody else in the family that did that. And then you die, the person dies, and they're not happy with that situation. And, lawsuits, it's so easy to file lawsuits anymore. People file them over everything. So it's not a good situation. So for 25 bucks or 30 bucks for a husband and wife one, I usually recommend that you do it in my office where it's in a controlled environment. We know that the proper steps have been taken for execution of the document. I can say truthfully later on the call to testify that I will not do these documents unless I know the person is competent to do them, and I make sure that the spouse doesn't sign for the other spouse, etc. Now, is it okay to sign an X? I'm not going to answer this one until some of you give me, I want to see a lot of yeses or nos on this one coming in. Is it okay to sign your document with an X? No. Come on, I know there's more than, okay, we got 2. I know, let me see how many's on this. We got 35 people on here, so One yes so far. No, no, no. Yes, no, no, no. The no's are carrying the election. I know you guys are all, I always do these the day after an election, but I'm not usually in competition with the vote counting that's going on like today. Well, the few of you that responded, yes with a witness. I like the last answer, Mr. Goodwin. I know you, John. Yeah. And John it's okay to sign. Ohio still recognizes the X as an appropriate signature. And with the way people sign their signatures anymore, an X is probably an improvement over what some people do. It's used like an art design, quite frankly, that you guys have anymore for signatures. A true story. So yes, you can sign with an X. And John is absolutely correct. If you don't have witnesses, you got a problem. I always tell people, and I still do documents where people sign an X, believe it or not. If you're going to sign it with an X, you should have a witness or somebody there that can certify or, sign. I would normally put at the bottom, if I have to handwrite it, that this person actually signed this with an X in my presence, and I knew that this person was who they are. And the notary law changed last year in September, and it's gotten a lot more difficult to do notaries anymore than it used to be. And as Eva probably knows, we now almost insist on getting a person's driver's license to prove, so we can prove who they are in this kind of situation. But if you know the person's familiar with you and you actually witnessed it, I think most courts are going to say it's okay to sign it with an X, but there should be somebody available to say who was there when they witnessed that, because obviously an X is a very nondescript kind of way of signing a document. But then again, the way people sign documents anymore, you don't know who they are anyway on it. So it is still possible. When my husband's health was failing, we got a medical ID USB that he wore that had all his legal documents on it, and any hospital can open and read them. Fantastic. However, most people don't want to wear a medical ID USB. But I do think that those kinds of things for the elderly are extremely useful to have. And I would, it's Bonnie that's really thinking out of the box, quite frankly, and doing something like that. The medical alerts are fantastic to have for elderly people that want to live on their own, but have issues. Sometimes they have memory issues. Sometimes they put these documents and you never can find them where they've put them. But always remember, in my office, we have a lot of these documents. Probably the overwhelming majority of people that do these documents in my office leave the original in my office for that reason you're talking about there for the most part. We don't charge for that to do that. It's their document. If they ever want, they can come and get it. But we also have a copy of the document too, so that we can send out to a hospital or someplace. And if I have the original, I'll always certify that it's in full force effect, because I know it is, because I have the original in my document, in my file. If I don't, I just send it, and 9 times out of 10 or 8 times out of 10, if it's coming from an attorney's office, the hospital, whatever, doesn't ask me if it's in full force and effect. If they do, I would have to tell them I don't know, because I don't have the original on it. So this USB thing would sort of take care of it, but there again, it's a copy of a document. If it's a USB that's being carried, medical alert thing that's being carried by a person, you could probably make the assumption that it's valid. But there again, Bonnie, who do we know who loaded? Probably that person did personally themselves load the information on the USB. But nothing's foolproof. We are all adapting to the current COVID-19 situation in unique ways. Can any of this power of attorney process be completely remote, not in person? I'm thinking about the elderly that are currently locked down in care facilities. The answer is yes, and it's always been yes. Believe it or not, I believe some of you might be old enough to remember when doctors did house visits and calls. I'm not sure. I see a couple people that might be candidates for remembering that situation. Believe it or not, I still do house calls as an attorney. That's even more rare. And it's a very minor cost, quite frankly. It's usually $50 for me to go to somebody's house or do it. Now, the COVID-19 has made that much more difficult, but it can be done. I can remember here during this situation in which I took some documents out to a assisted living, which I'm not going to tell you which one it is, and the person was on the inside. I was standing outside. The window was open. We both had masks on, and the documents were passed through the window to the individual, and the staff that was able to be in the room with the individual were the people that acted as witnesses. I explained the documents to the person through the window, standing outside, and the person signed it, and then the documents were passed to me back through the window back to me. So I can tell you it is still possible to do that. Is it possible to do these remotely, completely remotely? Yes, it is. And we do that. We do. Some people, I don't really care to do this because I lose the connection with making sure that it's executed properly. But I can, if somebody insists, talk to somebody via, I prefer Zoom or something where I can see them. I know who I'm talking to about the situation, do the documents, send it to them electronically with instructions, or mail it to them with these little stickies that say sign here, do this, and they do it and send it back to me. So yes, it is possible to do it. It always has been. COVID-19 has kind of moved it up to a little more frequently than it would happen otherwise, but I still do home visits, which I think are the best. I do meet with people that have handicap disabilities at the OU Credit Union down on Schaefer Street. They're good enough to provide me a room for doing that because their building is handicapped accessible and mine is not. My office is an 1860 vintage house on Congress Street, so it's not very handicapped, but I do go down to the credit union if I for handicap reasons, and there's no charge for that either if I do something like that. If someone dies and heirs are looking for their will and have no idea what attorney has it, how can they find the right office? That can be a problem because at one point in time, way before I started practicing, and I've been practicing, as Eva said, about 44 years now, wills could be filed with the probate court. You can't do that anymore. They don't want them. They don't want all these copies of them and so forth. So it's kind of, the wills that I do always have my name and stuff in an envelope that wills go in on the outside so that people can easily find who did the will, because your attorney's name is usually not on the will particularly. Most people have a place where they keep those. We also monitor obituaries, believe it or not. My staff monitors obituaries and cross-checks it against wills and stuff that we have. We have close to 4,000 wills and stuff in the office now, but we do cross-check those things. And so a lot of times what happens there is if we notice an obituary and we have the will, we send a kind of a stock condolence letter out and let people know we have the will. If you don't have any idea and the attorney doesn't do kind of like what I'm doing, or I miss somebody that believe it or not, a lot of these names sound familiar to me when I see them in the obituary and so forth. You're pretty much stuck to call around to offices and see if they have it. You're probably going to have some idea. If they use a financial institution, they might have a connection with the financial institution. In Athens, you only have about 50 phone calls to make. That's another joke, but yes, to find out. But a lot of times, be honest with you, the attorneys that do probate law, estate law, it's not 50 of us in Athens that do it. There are different specializations that different attorneys do, and you're really more down to about 10, something like that. So most of the time, this is not a problem because the person that died has a a non-safe, non-fireproof box that they bought at Odd Lots at 20% off, that they have all these documents in, and hopefully the house didn't burn down when it happened, and so you can find it. And if you don't find it in, over the a dining room closet where you hang coats on the shelf, it's probably going to be a document that they've wrapped in aluminum foil and stuck in their freezer. Another joke. Okay,
Can we jump back? I'm so sorry, but we did kind of bypass a question in the chat. So
sure.
If you don't mind, can we jump back to that real quick? And then we do have some new messages coming in. But the question was actually more in regards to real estate. So if real estate is transferred via the transfer on death affidavit or deed, does the deed get transferred automatically alongside the real estate to the same person? So does that happen automatically when that certificate is provided?
Yeah, it all depends. If it's transferred out of the probate court, it's not a deed. It's called a certificate of transfer, and it transfers to the heirs who's listed in the deed unless somebody buys it. And this gets confusing for people because they're used to seeing deeds, but when you if it's a survivorship deed and somebody dies, it's transferred by what's called an affidavit of succession under survivorship deed, which is basically an affidavit. And it's only transferring a part interest in the property. So you have to go back to your original one. But it does get transferred through the auditor's office and the recorder's office. If it goes through probate, it's called a certificate of transfer. And again, it transfers a half interest or some less than full interest, and it goes through the auditor and the recorder's office also and gets recorded. What people don't remember is that it takes your full ownership is both those documents. Does the property within the real estate get transferred? Real estate in Ohio encompasses the structures that are located on the property. For instance, the house, the barn, any structure that is located on the property is part of the real estate. And you'll notice when you get a real estate tax bill, it always says value for real estate, value for buildings and so forth that are located on it. If your question is, does the personal items that are located within the real estate get transferred? And the answer is no. Those are separate. They are not part of the real estate under Ohio's definition of real estate. So does that answer your question, Bethany? Or did I not answer it?
We got it.
Okay. Yeah. So yeah, the real estate, and that's a common kind of misconception. Real estate is not just the real estate. It includes the house and stuff that's located on the real estate. And if you don't want it to be, you have to, have that. If you take the house or off, it's quite possible. Most people don't realize it, but it's possible to have a modular home that has a title and cancel that title and turn it into part of the real estate. And then forevermore, it's transferred as part of the real estate. If you don't cancel the title, then it's personal property and it transfers separately from the real estate. I guess I have to have a will. It's best to have a will, especially for the cost in doing it, because it takes care of all these little glitches that, we try to get. For instance, cars, people come in and ask me about. It used to be, some of us that are older remember the days in which you, as an attorney, I would have to say, you can't drive that car. It's in your spouse's name. The insurance won't cover it. Blah, 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 you got to let it set. And they go, well, all three of my cars are in the spouse's name. And I go, well, that's not the smartest thing to have done, but it's better to split your cars up and have, one spouse or one significant other own one of them and the other one on the other one is easiest. But anymore, the Auto Title Bureau will transfer, I believe it's up to 3 vehicles. It might be a lot more than that right at the moment, by just showing them a copy of the will that you get it if you're a spouse or I think they'll do it for a child also. And if they don't do it, it's really pretty simple for me to get the probate court to authorize the transfer of vehicles anymore too. It's not anything that's going to take months on end. And the insurance companies usually will let you drive them anymore for at least a reasonable period of time, which is, 6 to 8 weeks or something like that. So we want to let the insurance company know if you're going to be driving it and so forth, but they're not anyways near as sticky as they used to be about that. So cars are much easier to do. Probate's gotten pretty much more streamlined and so forth. So we're down to the trust situation. I used to kind of tell people on that one.
More question, if you don't mind. We had one that came in as part of that exchange. So it's, what if you would like to give some of your money to an NGO, but you want the executive of your will to ensure that the NGO is still active, so that if the NGO is no longer active, what would be another option? Was the question that came in there.
Sure. Just for those of you who don't know what NGO stands for non-governmental entity, organization, and usually they're nonprofits, and usually they continue on in existence. But what you would do in there, you would just say it would go to, I'll just mention a NGO I'm familiar with, the World Jurist Association out of Washington, D.C. It goes to the World Jurist Association so long as they're in continued existence. If they're not, then the gift lapses and it goes to ABCY or somebody else, kind of thing. So it's fairly easy to take care of. And of course, the court will not permit you to give a gift to somebody who's out of existence. For instance, if you gave it to a live person and the live person died and didn't have any beneficiaries or any will, then it just lapses. So, but it's best when you think about those things to take that into consideration and you go ahead and make the language say to the particular NGO, as long as they are in existence or a viable organization, or whatever you want to say about it. It's your money. I hate to use that TV commercial. It's your money and you want it now. It's your money, but you can decide who gets the property. As I started to say on trust, the trust situations I usually talk to people about, these kind of situations are the trusts that go within a will, or a trust that freestanding, that's to take care of a specific child situation, so that you don't have to do a guardianship. But certainly if you have a son or daughter who has special needs, we would probably set up a guardianship for them, which is much more formal than a trust. The difference between a trust and a guardianship is the trust does not have oversight by the probate court for the most situation. There are some situations in which you create a trust and a will and the court will stake around in the background, but certainly in a guardianship, the court is in the background and is monitoring the situation and controlling it. I will mention to you that it used to be that your grandparents give your minor children $25,000 each. And remember I mentioned earlier that children can own property, but they can't dispose of it. And parents would just put it in a bank account or something as the parent and natural guardian over the child. They don't like that anymore. So you have to go to the probate court and tell them you're going to do it. And then normally you would have to file an account once a year. The probate courts usually just make you put it into an account anymore that says that it cannot be spent without court approval until the children reach 18 or whatever age they were supposed to be to get the money. And all you do is send a documentation to the court once a year showing that money is still there. But the language with the financial institution is such that they can't do anything with it anyway without the court approving it. So that's kind of like currently where we are. It's a little bit more formal than it used to be for protecting children, but they still can inherit money, and a lot of children do from grandparents and so forth. And they can't really do anything with it without court approval until they're adult. Questions? And we were a little bit over, well, about an hour and a half, so we're a little bit over time, but every time I do these, they go over an hour anyway. Usually though, if you come in person, the credit union is gracious enough to provide you food and drink. Non-alcoholic drink, obviously.
Non-alcoholic, exactly. We did have some questions come in, Gary. So we've got, does a guardianship protect the special needs child from income/assets that could interfere with state support, like special needs trust does?
Yeah, does the guardianship protect the special needs child from income assets that could interfere with Not really. If you would not, if you have control of the money, you would not want to give it to them in an outright trust in that situation. You'd want to create the luxury trust or the special needs trust for that money, and then have the trust pay the money to the child as needed in accordance with that, to avoid what you're talking about, the SSI and Medicaid sometimes issues that you would have. What documents should I prepare to bring with me for an appointment with you for a simple will? You can come unprepared, and then we can have one conference, and you can come back for a second conference, or you can come a little more prepared. And what I normally is to sit down and think about the things I've talked about, your assets, who you might want to have your assets, what you own, how it's currently titled. And if you do that, it makes the appointment a lot shorter and better. We could do it. If you really want to be on the ball and do it, bring in your deed, a copy of your check register or bank statement, so I can see how stock certificates. Remember, I always tell people, next to your priest, I'm the most confidential person you can talk to. I don't see much responses on that. It is true. Attorneys are obligated to keep confidential the conversation, and we take that very seriously. In my office, if I do documents for you and somebody were to call me and say, does so-and-so have a will, we would answer yes or no to that particular question. If there was a need for them to know, my first question would be, are they deceased? And if they said no, I would say I won't answer that question. If they tell me they are deceased and we have record of it, then I would tell them. And then if they ask me what's in the will, I would say, I can't tell you. I will look at the will and contact the person that is should have that information. So we've got, if you have assets in another country, can it be part of your will here, or do you have to have that will in that country too? Other countries are a problem, and it depends on the country. If it's China, it's like ordering something over Amazon from China. You can expect to receive it about 2 months after you ordered it. It's kind of the same thing when you deal with them on these kind of things. It goes through the American consulate. So certainly if it's in a country in which we have an American consulate relationship, it is easier. It's usually a mess. I will be honest with you. I've had some in England. They're not too bad there. I've had some in Germany, not too bad. It can also get situations where, the person wants to be buried in that country and they die in the United States, and it's a mess. Try to avoid it. I mean, but the countries do have relationships with other countries, and we can do it. It usually, if you own assets in another country, if it's a beneficiary in another country, it's not as much of a problem. If you own, a summer home in England, it's going to transfer in accordance with the laws of England, quite frankly, but they're probably pretty similar to what we have. If you have a summer home in China, it doesn't. Their rules of law are different than ours, and so it's a much different process. It's not pleasant, but it can be done. Is there any other questions? To answer that last question, so it would be wise to have a will in that other country too, if you have assets in that country. Then.
It looks like we have answered all of the questions. I'll just make an announcement for folks who aren't watching the chat. There will be a recording of tonight's presentation. We did cover a lot of information today, so that will go out by email, most likely by Friday, if not tomorrow, so that you can review that, as well as a copy of the slides and the supplemental material that Gary has provided for you.
And again, if you have any questions, you want to talk to me privately, that's perfectly fine. You can either send me a text, as I indicated. You can call the office, and I will tell you a lot of times you're not going to get through to me if you call the office, but I do return phone calls. You can probably the best way to talk to me is an email, and I didn't give that email here, but I will give it out. All pens in hand.
Type it into the chat as well, Gary. If you want to say it, I'll type it out, and then it'll be in the chat if folks want to copy and paste.
Sure, it's G Hunter, all lowercase, at Hunter Law Offices with an S.us.
Hunter Law Offices with an S.us.
Right.
All right, you can double check me as well. It's in there as well as the link to the survey. We'd love to hear any feedback you have about today's session. If you want to go ahead and click on that link, you can pull it out now, or I will include that in the follow-up email as well for folks who need to run and get off the call tonight.
All right, thank you all.
Thanks so much, everybody.